All right, this is case number 23CR43, State of Ohio versus Tyler J. Hunley. And are you Tyler J. Hunley appearing there from the jail? All right, Mr. Hunley, Probation Department filed a notice of alleged violations yesterday. You were put on community control back on May the 4th of 2023 on charge of misuse of credit, 2 counts of misuse of credit cards, 5th and 4th degree felony. This is a notification hearing. He's apparent, Mr. Hunley is appearing from the jail. Officer Parr, the probation officer, and Tanya Sturgill, drug court coordinator, are also appearing by Zoom. And Mr. Parr, did you notify the victims of the offense that would be hearing on this today?
I contacted victims' witness. They said there was notice.
Okay. All right. Now, Mr. Hunley, the allegation that was filed alleges that on or about the 28th of May, which would have been March, which would have been Friday, apparently after drug court, that you tested positive for amphetamines, methamphetamines, buprenorphine, and alcohol in violation of Rule 7. And Mr. Parr signed that yesterday. It looks like you also signed on the same date. You did get a copy, is that correct?
Yes, sir.
All right. Now, you, the offenses you are charged with, one's a 4th degree felony, or I mean, you pled guilty to. One's a 4th degree felony, which carries a possible prison term 6 to 18 months, and the other is a 5th degree felony, which carries a possible term of incarceration of 6 to 12 months. And total fines on the 2 charges are $7,500. Now, in the event that you're found to have violated the conditions of your community control, the court can do one of 3 things. I could continue your community control under the same conditions I previously ordered. I could continue it with additional conditions that I think are appropriate. The third and the most serious is I could terminate you from the drug court docket and revoke your community control and sentence you to incarceration for a total of 30 months and fine you a total of $7,500. And you understand that?
Yes, sir. You're
entitled to have a hearing on this allegation, Mr. Hunley, in which the state, through the prosecutor's office, would have to present evidence and support of the allegations that convinces the court that you've committed these violations. You're entitled to have a reasonable period of time to prepare for that hearing. Usually it's about 10 to 14 days. You have a right to subpoena witnesses to testify on your behalf, the same as the state. You have a right to have counsel to represent you, to cross-examine the witnesses that the state may offer, as well as to offer testimony and evidence on your behalf, and to generally assist you in advocating for yourself regarding this matter. If you do not have the money to hire an attorney, the court will appoint one for you at no cost. Now, Mr. Hunley, do you wish to have an attorney to represent you in this matter?
No, sir.
All right. You do not wish to have an attorney, is that what you said?
No, sir.
Okay. You understand if you don't have the money to hire one, the court will appoint one for you and you won't have to pay for it?
Yeah, I guess I can take it for one then, yes.
You wish to have an attorney then?
Yes.
Okay. All right. And so, looking here, your attorney was Danielle Witt. Okay. All right. We'll need you to fill out a financial affidavit or financial disclosure form. You didn't fill one out, did you?
No, sir.
All right. The deputy there will have you fill one out. And I know you're working, but since you're incarcerated, I assume you're not making any money. Is that correct?
Yes, sir.
All right. And do you have any money in the bank that you could pay an attorney?
No more, yes.
All right. Well, assuming that you'll fill out that financial disclosure form, and assuming that you meet the qualifications, which I believe you will, the court will go ahead and appoint Ms. Witt to represent you in this matter. The trial on the 10th is out, right? Okay. We'll set this matter for hearing then on April the 10th at 1 p.m. And you'll be held without bond until that time. We'll notify Ms. Witt of her appointment, and she'll be in touch with you. All right. You have any questions? All right. I think we have a different invite for the 2 o'clock hearing, Deputy, so I'm going to go ahead and close the meeting then. Thank you.
Okay.
This is case number 24CB 300, UC Health versus Elizabeth F. Is it Haney or Haney? Haney, H-E-Y-N-E. And counsel plaintiff, what is your name, sir?
Deputy Mayor Chad Hirschauer on behalf of the plaintiff.
Okay. And for defendant?
Inspector of the defendant.
All right. All right. This is, and where are you from, Mr. Beck?
Office is basically in Lubbock.
Lubbock, okay. This is a hearing on damages on a default judgment. The plaintiff complaint was there's no answer filed, and so upon motion of plaintiff, the court granted default and then set the matter for hearing on damages today. So you're prepared to go forward, Mr. Hirschauer?
Yes, as needed, Your Honor.
All right.
Your Honor, I've been provided information from counsel this afternoon that gave adjustments that we thought were due based upon the original complaint. I represent the Haneys in the action pending arising from the motor vehicle accident which precipitated this medical treatment at UC Health. I have a hearing there tomorrow with probably Judge Gusweiler, who may be done by Magistrate Zook, on issues regarding the application of the pro rata statute in Ohio because we're going to have liens that exceed the insurance coverage. So my interest was in confirming the amount of this lien, so I'm in a position to advise the court tomorrow. I've been given a revised summary of the charges, and I have no reason to believe that those charges as now adjusted are properly accurate. We thought there were issues that were not addressed based upon the original filing and the suggestion, but it's been significantly adjusted down, so I'm not contesting.
Okay, what is that about?
Your Honor, so one of the invoices was not reduced down for the No Surprises Act, so we had to reduce that down. It is invoice ending in 4110. It has been reduced to $88,240.19, bringing our overall balance to $120,748.72, as opposed to the $175,000 that was previously requested.
Okay.
And I believe that was the invoice that they were believing needed an adjustment, which it did. So now I believe that it is reduced down to the proper balance, and I don't believe that they are objecting.
So you agree the amount of $120,748.72?
Yes.
Okay. All right. And in terms of your case in Brown County, what's going on with that? Is that a status conference or something tomorrow? Or?
It's a conference tomorrow, partially to address the application of the pro rata statute. I adopted the pro rata statute,
right,
where there's liens that exceed the available insurance coverage, then to decide how funds are going to be dispersed. So that's the primary issue for tomorrow's hearing.
Okay. So do you have you anticipate a settlement then after that, or is it you think it's going to be a trial or what?
The carrier has extended coverage because the liens on Ms. Haney's behalf would have exceeded the coverage. Her husband was also involved in the accident,
okay,
and his medicals are 3 or 4 times hers.
Oh.
He was airlifted from the scene. So,
okay.
Yeah. So it's just a matter of how the court's going to allocate the percentages on that distribution.
Okay. So then you're agreeable to judgment just going ahead and being entered in this case for the agreed amount?
Yes.
All right. Okay, the court then will grant the judgment, and I don't know, did you submit an entry, Mr. Hirschauer?
I'll submit a new entry, because we do have a new balance, if
all
that's
right,
okay. So we'll submit a new entry.
All right, submit a new entry and get approval for counsel, and then just send it to the court. Then.
Yeah, I'll send it as an agreed order, or
okay,
agreed entry, if that works for you.
That'll work. All right.
Perfect.
Thank you.
Thank you, Your Honor.
Judge Cross, I noticed the picture already has a date. They plan on kicking you out?
Yeah, I thought I'd be optimistic. Yeah. All right, this is case number 25 CR 23, State of Ohio versus Nicholas V. Tobin. Are you Nicholas V. Tobin appearing there from the jail?
Yes, Your Honor.
All right, this is a hearing set for a plea at the request of the parties, and the hearing is being conducted by Zoom. The defendant's attorney is Dennis Kirk, appearing from his office, appearing on behalf of the state. From the prosecutor's office is Assistant Prosecutor King. Mr. Kirk, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor.
And is that all right with you, Mr. Tobin?
Yes, Your Honor.
All right. Since you're not seated with your attorney in the courtroom, if at any time during this hearing you would like to speak with him or ask him questions, just tell me and I'll put the two of you into what's called a breakout room. It'll be just you and him on the screen. No one else will be able to see you or hear you. The deputy will step out of the room during that time so that your consultation is private. Okay?
Yes, sir.
Now, the defendant is charged with rape and sexual battery, and Mr. King has the alleged victim or representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor. The alleged victim and representative have been notified, and I believe they're monitoring this hearing on YouTube.
Okay. Now, Mr. Tobin, I believe your trial is set for the 10th of April, and the court was notified late last week that there had been an agreement reached. I do have a Alford plea of guilty form here, and it says that you're going to withdraw your not guilty plea and enter an Alford plea of guilty to the first count of the indictment, rape, under 290702A2. I'm going to hold that first page up to the camera and ask you if you recognize that document.
Yes, Your Honor.
On page 4, there is a sentence at the end of the text that reads, "I enter this plea voluntarily." Below that is a line with signature defendant printed underneath that. And I'm going to hold this up to the screen and ask you if you recognize that as your signature.
Yes, Your Honor.
When did you sign this document, Mr. Tobin?
Yesterday.
Okay. And when you signed it, did you understand that it's an agreement to plead guilty through the Alford case, which I'll explain in a moment, and that means that there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir. Yes, Your Honor.
And before you signed it, did you go over this with your attorney, have him explain everything to you, and answer your questions?
Yes, he explained it.
And do you feel you had enough time to fully consider the matter before making this decision?
Yeah, I think so.
All right.
Yeah, Your Honor.
Well, and you've had a day or so to think about it. You haven't changed your mind?
No, sir.
You're
No,
going,
Your Honor.
and you're going forward with this voluntarily.
Yes, Your Honor.
All right. Now, the first page of the agreement states that you're going to plead guilty to count 1 of rape under 290702A2, a first-degree felony. States that you understand that the maximum possible sentence for that, or the sentence for that, can be anywhere from 3 to 11 years. The 3 to 11 years is what's called the minimum sentence, and so that the judge picks one of those numbers, and then that is the amount of time that has to be served, because this is a mandatory prison sentence. There's no possibility of probation or early release. And then under the law, Reagan-Tokes law, that sentence can be extended by the Department of Rehabilitation and Corrections. Now, the way it works, I'll give you an outline of this. It's set forth in your plea agreement, is that whatever the number is, let's assume worst case scenario. Worst case scenario is 11 years. So you get an 11-year sentence, and you get credit for whatever time you serve locally before the court sentences you, and then after that, DRC gives you credit. Once you reach the 11-year mark, then there's a presumption you'll be released. And that means you will be released unless the Department of Rehabilitation Corrections overcomes that presumption, and a hearing officer makes certain findings based upon, the factors they make findings are what your conduct was while you were confined, what your rehabilitation has been, the extent of it, what your threat to society might be, whether you were in any restrictive housing while you were incarcerated, and whether what was the nature of your security classification while you were incarcerated. And so if the department overcomes the presumption regarding after determinations are made by the hearing officer and then the department regarding those items I just explained, then the department could decide to extend your incarceration by up to 1/2 of your sentence. And so if 11 years was the maximum that you received, that means it could be extended up to an additional 5.5 years. So that means that your maximum sentence could be as much as 16.5 years. Now, they could do that in increments. They could say, okay, we're going to extend it 90 days, we're going to extend it a year. We can extend it 2 years. And they can do it more than once, but they cannot extend it to a total of more than half of the prison term, which in the 11-year example was 5.5. If it was the minimum sentence of 3, then it would be a 1.5 years that could be added on, again in increments, but no more than the total amount of time. And then once you reach that number of the extension, the last extension, if there has been one, then at that time you would be released. Now, do you understand that?
Yes, Your Honor.
Okay. Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you on community control, probation, parole, or post-release control for a felony?
No, Your Honor.
All right. Now, under the law, if you are convicted and sentenced to prison, once you serve the prison term that was imposed by the court, plus any extensions, if any, that were made by the department, it is mandatory then that you be supervised under post-release control under terms set by the Adult Parole Authority for a period of 5 years. And if during that period of time the Adult Parole Authority determines that you have not complied with those conditions, then they could return you to prison as a sanction for up to 9 months for any single violation, but there is a limit or cap of half of whatever the prison term was for all violations. Now, if you commit a new felony under post-release control, then in addition to whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that would have to be served consecutively to the sentence in that new case. Do you understand that?
Yes, Your Honor.
Okay, and I'll note that on your plea form, the community control or probation part is lined out because, again, I have no authority, if you're found guilty or plead guilty, to do anything other than sentence you to prison between 3 and 11 years on this charge. You understand that?
Yes, Your Honor.
All right. So the charge in count 1 alleges that on or about December 4, 2022 in Highland County, Ohio, you did engage in sexual conduct with V, and that you purposely compelled V to submit by force a threat of force, which is in violation of Section 290702A2 of the Ohio Revised Code and is a charge of rape. Now, do you understand what it is the state has charged you with, what they said you did, when, where, and how they alleged that you did it?
Yes, Your Honor.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2, at the bottom of the page, there are just a little over 2 sentences that are printed in bold and underlined that I'll read as follows. Defendant shall under Alfred plea of guilty to count 1. State will dismiss count 2. State defense will argue sentencing. Defendant shall be a Tier 3 registered sex offender. Is that your understanding of the agreement?
Yes, Your Honor.
Now, has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Right now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No, Your Honor.
Now, you have certain constitutional rights you must understand before I can accept a plea of guilty under the Alford decision. And so I'll go over those at this time. First of all, you have right to counsel, and I appointed Mr. Kirk to represent you. That appointment wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So if you decide you don't want to plead guilty and you want to defend against the charges in the indictment, then he'll continue to represent you, including trial, if that is what you want. Do you understand that?
Yes, Your Honor.
All right. Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those individuals are selected, the evidence will be presented, the judge will instruct them on the law. Then that jury of 12 would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, in which case you would have what's called a court or bench trial, meaning that instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in public in front of you and your attorney and anyone else who may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're certainly going to come in voluntarily, at your request, the court will issue a court order called a subpoena, and that would force those witnesses to come to court to be able to testify if you wanted them to, even though they didn't want to be here. That's the same way state's witnesses are required to come to testify against you. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can't, the judge can't. You make the decision. And the fact that you decide not to testify cannot be used against you in any way by anyone at any time in the proceedings if that's your decision. And in fact, no one's even allowed to talk about the fact that you did not testify, except in one situation. If there is a jury trial and you don't testify, then the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir. Yes, Your Honor.
Now, under the Constitution, Mr. Tobin, you're presumed innocent of the charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else who may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose has to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
All right. Now, originally you entered a plea of not guilty to this charge. Not guilty plea denies the allegation in the indictment, denies you committed any crime, and exercises or invokes all of the rights that I've just described for you. Now, a standard plea of guilty is a complete opposite. A guilty plea waives or admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that is typically what a guilty plea is. However, in this case, the proposed plea is what's called an Alford plea. Now, that Alford plea is made under the holding of the United States Supreme Court in the case of North Carolina versus Alford. And basically, what that is that a person maintains that they're not guilty of the charge. But after consulting with their attorney and in recognition of the evidence that is available to the state of Ohio against them, a person may decide that even though they're maintaining their innocence, that it's highly probable that they're going to be convicted of the charge or all charges, and then therefore could be exposed to a higher penalty, more than one conviction and more of a sentence. And so under the North Carolina versus Alford decision, the person that enters that plea of Alford, guilty under Alford, is maintaining that they're not guilty and innocent of the charge, but are doing it because they realize that going to trial means they'd probably be convicted and suffer greater consequences because of that. And so that plea then waives the right to have a jury or court trial that I explained to you earlier. It waives or gives up the right to cross-examine the witnesses against you in open court through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf to save the state because there's not going to be a trial. It waives, gives up your privilege against self-incrimination to the extent that you're admitting guilt under the Alford decision. And it waives, gives up your right to require a trial at which the state has to prove your guilt by proof beyond a reasonable doubt on each of the elements of the offenses charged. And that would be the highest burden of proof that's known under the law. And so your Alford plea would waive all of those. It could also subject you to being sentenced immediately by the court if the court chose to do that. And finally, an Alford plea would waive or give up any right to file an appeal that you think you may have up until this point in the case. Now, if I should sentence you to the maximum sentence or under other limited circumstances, you could file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I believe so, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
All right. Now, Mr. King, has the state consulted with the alleged victim and or representative regarding this disposition?
Yes, Your Honor, and they have approved of this agreement.
All right. Now, I believe that under the law, that in order to accept the plea, the court has to have a factual basis that the state alleges would be presented. So if you could give me a summary of that this time.
Yes, Your Honor. So this incident occurred back on December 4th of 2022. The defendant was in a relationship with the mother of the victim. The victim was 14 years old at the time. The defendant and his girlfriend had been in an argument on the evening of December 3rd of 22, and the defendant's girlfriend left the house and slept in her vehicle. The defendant and the victim remained inside the residence, which was located on Northwest Street in Hillsborough, County, Ohio. The victim advised that the defendant and herself had been on separate ends of a sectional couch and she had fallen asleep. She later woke up to the defendant pulling her pants down. The victim advised that she was lying face down on the couch and told the defendant to stop. The defendant then pushed the victim's face down on the couch, and the defendant pulled the victim's pants and shorts down partially. The victim advised that the defendant inserted his penis in her vagina and had sexual intercourse with her. The victim indicated that the defendant ejaculated inside of her and then let her up. The victim then pulled her shorts and pants back up and also vomited before going to the bathroom to take a shower. The victim disclosed this incident to her therapist 3 days later, and the victim and her mother then arrived at the Hillsborough Police Department on December 9th of 22 and reported the incident, and also brought the pants and shorts that the victim had been wearing at the time of the incident to the police department inside of a plastic bag. Following this incident, the defendant relocated to Florida. He was eventually arrested in Florida in January of this year. He was transported back to the Highland County Justice Center. Detective Butler then obtained a search warrant for DNA standards for the defendant and collected oral swabs from him, which were submitted to BCI for analysis to determine if the defendant's DNA was inside the victim's shorts that she had put back on following the incident. The results of that analysis at BCI discovered that a YSTR DNA profile consistent with the defendant was ultimately found on the interior seam of the crotch area of the shorts that the victim had put back on following the incident. So, Your Honor, that's a brief summary of the evidence that the state would have presented at trial had this matter proceeded to trial. Thank you.
I would note I was examining the affidavit that was filed originally when the arrest warrant was issued back in 23, and there was reference to a conversation that the defendant had with his daughter. Is that a person different than the alleged victim?
Yes, the alleged victim is not the defendant's daughter.
And could you is what is contained? I'm looking at this affidavit in the file that's dated February 13th, 2023, and I believe that would be Officer Brian Butler's signature. Yeah, he's the affiant. And there was a statement that was allegedly the defendant made certain statements to his daughter identified as KT, and are those accurate representations of the evidence the state has?
So that statement was allegedly made by the defendant to his daughter. However, Detective Butler attempted, by checking phone records, to confirm that this call occurred and could not find any record of that call.
Okay.
So that's why I didn't delve into that.
All right, fine, that's fine. Okay. All right, now, Mr. Kirk, you agree that that's the state of the evidence will be presented against your client if this matter went to trial?
I do, and I have gone over those allegations with my client. He is familiar with them as well.
All right, as well as with the results of the DNA test?
Yes.
Yeah, okay. All right. So, that's the evidence that's been summarized that the state says would be presented. And so if you enter a plea of guilty under the Alford case, Mr. Tobin, although you're denying your guilt, you're acknowledging that that would be the evidence that would be against you in the case, and that you're doing this because you feel that it's the best thing to do to avoid the consequences of a possible or even likely conviction of all the charges against you, and therefore subjecting you to greater punishment. You understand that?
Yes, Your Honor.
Okay. Now, do you have any questions then about the charge or the possible penalties in this case? You understand?
Probably.
You understand them?
Yes, sir. Yes, Your Honor.
All right. You understand the plea agreement?
I believe so, yes.
And you understand there's no specific recommendation as to a period of time. There's going to be an argument, so I assume you and your attorney will argue for a low sentence. State will probably argue for a higher sentence, and so the court can pick any number in that range. You understand that?
Yes, Your Honor.
Right. And do you understand the constitutional rights I've explained to you?
Yes, Your Honor.
And you understand what the Alford plea of guilty means in this situation?
I believe so, Your Honor.
All right. I don't think I asked you this. Are you a U.S. citizen?
Yes, Your Honor.
All right. Now, is there anything you would like to speak to Mr. Kirk about before we go any further, or are you okay to go forward now?
I believe I'm okay to get forward.
Okay. Do you have any questions about anything that I've explained to you today?
I don't believe so, Your Honor.
Then is it your decision, Mr. Tobin, to withdraw your not guilty plea and enter a plea of guilty under the Alford decision that maintains your innocence but acknowledges the likelihood of a conviction and consequences of a trial? Is that your decision?
Yes, Your Honor.
All right, then, as to the charge which alleges in count one that on or about December 4, 2022 in Highland County, Ohio, you did engage in sexual conduct with V, and that you purposely compelled V to submit by force or threat of force in violation of Section 2907.02A2 of the Ohio Revised Code, charge of rape, a first-degree felony, carrying a mandatory penalty of between 3 and 11 years as a minimum set by the judge, with the possibility of that being extended by up to 1/2 by the Department of Rehabilitation and Corrections under the terms set forth in the plea agreement and as explained by the court. How do you plead?
But the Alfred plea,
Of Alford plea of guilty?
the Alfred plea.
Is there something there you have to read that you?
No, just set the record.
Okay. So your plea is, again?
Alfred plea of guilty.
All right, thank you. All right, the court finds that on this day in open court, The defendant was advised of all of his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. The defendant is found guilty of count 1. Count 2 is dismissed. Court will order a pre-sentence report as requested by the parties. And the sentencing will be set, let's see here, for May the 7th at 9 a.m. All right. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. The probation department will be in touch with you, Mr. Tobin. Thank you.